This is another episode in the series of episodes we're doing on AI, the legal aspects of AI with Damon. As I said, today we're talking about copyright and IP. So Damon, can you start by telling us a little bit about how is copyright and IP of AI output treated in general, both globally and also in some specific geographies as well?
Yes, of course. Yeah, there's so much to talk about with copyright and intellectual property. There's really two key areas. It's very much the copyright of content that's going into the training, and then also the copyright of an intellectual property ownership of the content that's being produced by, for example, generative AI models. And the approach does differ, as you've suggested, in the US and the UK and the EU. There's very slightly different approaches, and then often it's a very Western or Northern Hemisphere perspective. But if you look at some developing countries as well, a whole nother different perspective there, where they might not have such strict or ability to enforce intellectual property rights like we do. We've got so many cases that are live right now, which are really, when these are concluded, going to pave the way and set the direction of where this is going to go. So to some extent, we've got old laws in place that kind of set how this should be treated, how copyright and intellectual property ownership should be. Then there's also newer laws like the EU AI Act of 2024, and also the intellectual property offices of like the UK and other countries also kind of made some rulings already or kind of defined their approach. But I think there's some really big cases live now that are the next step to set the direction of it. So it is still in flux, but I think it's reasonably well known, and some good, sensible kind of judgments can be kind of made now on copyright and intellectual property.
Thanks, Damon. One thing I want to talk about, which is always what I wonder when I think about this topic, is of course, the training AI models is the key aspect here. How do you distinguish between fair training, so training on data that you can use, and training on data that you cannot use, that is copyrighted? How do current laws handle this distinction? I know it's already a little bit specific, but maybe you can talk a little bit about that.
Yes, of course. Yeah, it's the fair use point, like specifically those words, is probably the greyest part. But there are some laws that do set some rules on this, and I think the main one is the EU AI Act of March 2024. So they actually have set very clear parameters as to when you can use other people's data. So if anyone wants to look it up, it's Recital 105. But effectively, it says that you can scrape other people's data. So scraping is basically just grabbing, for example, content that's off of the internet. You can do that and use it for research purposes, pretty much across the board. Now, if you want to use it for commercial purposes, there is the option for copyright holders. So if it's your website, you can mark that you're opting out of this. And if you opt out, then it can't be used at all. The problem is they haven't actually said how you opt out in practice. So there's no kind of definitive standards. And to some extent, it's also similar to when kind of GDPR came out. Like so many different pop-ups and so many different like privacy policies and different ways on websites coming up about you having to agree. And in fact, with GDPR, it's very much opt-in. This is the opposite, which is kind of interesting that they've taken that approach. But with that, because GDPR, there was no standard kind of pop-up, you can't set on your web browser, I want to just accept all of them or deny all of them, because everyone's implemented it differently. So then how are these AI providers meant to check your site and know that you've opted out if you're not told how to consistently do that? They're going to have so much extra code in that, and they're just not doing it. They're still continuing to scrape. But generally, though, the fact that there's kind of licenses coming out as well to use data for AI training suggests that at least the people that are producing these licenses, their intention is that it's not permissible to use their copyright for training unless you have a license. But again, if that's not on their website and they post their video on YouTube, they put it on Netflix or wherever, how do you opt out on other platforms as well? So even though you might say on your website you've opted out, what about the other places that are distributing your content? There's no fixed way. And if you opt out over on platform A, does that mean you're opted out on platform B? And if they take it from platform B, that's okay. But the reason why I cite the EU AI Act in particular for this one is previously, when it comes to training, the laws of the country you're training in are what matter. So there have been some examples where people will train in a more kind of permissive jurisdiction and then use it in a country where it's not so permissible. But actually, under the Act, if you are selling your model into the EU, then you have to comply with the Act. So that's a really good shift that then means that they can force that. And it's going to catch a lot of big kind of AI companies out.
Yeah, no, that's very interesting. That the fact that they were kind of trying to evade the law in this way. You mentioned I want to talk about other key concepts when it comes to copyright, but before I do that, I want to ask you about those big cases that will set the course of the future you mentioned. Are there any examples you can share, and what do they say about the future of IP and copyright?
Yeah, so I think the big cases that there's been some past big cases on scraping, but in terms of the current cases that are relevant in defining who owns the output of AI, the current ones at the moment are there's a case from Getty Images against the Stability AI. So their grounds is that Stability AI have used Getty Images without a license to train their model. And it's because the way that they've been able to tell is because the output is actually reproduced in the Getty watermark. So it shows that they've scraped the publicly available kind of free version of the image that where you don't have a license to use it to train their model. And there's been already some interesting rulings where, again, they tried to argue, oh, well, we didn't train it in the UK where the case has been brought. So therefore, we it doesn't matter that we've grabbed the data from there. And the judge has thrown that out, which is quite interesting, that argument at least. And there's also that whole fair use thing. Is it fair use to grab someone else's copyright and then use that for training your stuff? But it does also raise a point that it's very difficult because if you don't, in this example, Getty Images have so much data that and a recognizable copyright watermark going across stuff that it's much easier to tell that the content has been used. But what about if you are a very small artist or a small writer and you've only produced a handful of books? How is it actually possible to tell? So we do have a couple of other cases. There's the Authors Guild versus OpenAI, and a multitude of news agencies who are also suing OpenAI for breach of copyright or copyright infringement, because effectively, again, they can see that because they've produced such a vast body of works that their output has been used, their content has been used in the output of these generative AI models. So the thing that is changing, though, to make this a bit easier for the smaller authors is the EU AI Act has said that if you are using the copyright of others, you're going to have to publish that you've used it, and it's directly to make it easier for kind of small copyright holders to be able to enforce their rights. So that would be interesting to see if Stability start conforming with that, because they'll have to show that they took all the data from Getty, which I don't think they've done yet. They'll probably wait till the output of the case, but then technically they're in breach of the law until they do it.
Yeah. Thanks, Damon. That brings me to probably one of the most important concepts in this discussion, which is ownership. So ownership, who owns the copyright of the content created by AI tools? Because if I'm using generative AI, I might create something. Increasingly, I might create images. We've recently seen like a lot of social networks being invaded by all these Studio Ghibli images, which are, they're iconic because, of course, it's like high quality art, but then in the hands of course, it's different. But a lot of people being able to create something in the style of an important artistic expression, let's say. So who owns it? The user? Well, if I'm creating something, do I own it? Does the platform own it? Does the original copyright holder owns it? What's the kind of state of play in this area?
Yeah, it's a great question. This isn't another one where it really differs depending on the countries. There's some similarities, but in the US, it's pretty much definitive that it has to be produced by a human in order to be ownable or to be copyrightable. There are some past cases on this that are totally unrelated, but also quite fun to talk about. There was an example where a monkey took a photo, I think a selfie of itself with the photographer's camera. And then that photo was used elsewhere. The photographer tried to enforce their rights on that. And they said, well, you didn't produce the content. It wasn't produced by a human, therefore it's not copyrightable. But then more recently, it's a great case. It's a really, really fun one if you want to look it up and read it. But there's been some more recent ones where I think it was the Supreme Court in America actually ruled on some output, people trying to protect the output of what's come out of these generative AI models. And it was a strict requirement, is what it's defined, that it has to have human authorship. There has to be like an element of kind of creativity beyond kind of minimal. So it might be okay for you to produce like an image or a poem or something out of an AI model, but then you have to modify it sufficiently that it's had human authorship in that process. It can't just be an assistant. It has to be you produce the work. That final piece is materially different and almost a new piece of work in itself. So in that vein, in the US, it's quite clear that if a human didn't produce it or didn't have a significant, beyond minimal creative input into it, so a prompt won't count. Oh, I wrote the prompt, or I trained the model, therefore I own the output. No, it has to be that a human authored in a material way the output. Yeah. While again differing in different countries. So in the UK and EU is fairly similar in terms of favouring kind of UK authorship. But in China, there's more kind of robust protections for AI generated works. If you think about it, there's problems where if you are making content with these platforms and then diverging and offering in other countries. So if I produce something in America and then offer it to other countries, what's the problem? Like, do I own it? Do I not? Well, the US says not, but if I'm publishing it into a country where it's more liberal, then that's okay, perhaps. But there are also some conflicting opinions. So in the UK, while it is more favouring kind of human ownership, if you look at, it's an old act, it's the Designs and Patents Act. I think, I can't remember the wording exactly, but I'm pretty sure it's the person who orchestrated the works is the owner. So in our case, it would be that the model isn't necessarily, the model producer isn't the owner of the output, but the person who wrote the prompt is then the one that orchestrated the creation of it, and therefore they own the output. So it does differ across countries, and that definitely creates a problem in terms of protecting the output depending on where you're going to publish it, because you could be challenged in one country but maybe not challenged in another. So when people are using it to produce stuff they want to protect, they need to consider these things.
Thanks, Damon. And that makes, I guess it's difficult to understand what's, beyond the minimal effort, but the concept of it makes sense to me because, even if you're thinking about art and people that create content, I'm thinking about, for example, cinema, I can think about directors that kind of, whose work was inspired by previous people, but that then added something to it. If that makes sense. So, that's creativity for me. But then if you're completely reproducing someone else's work, it's not. So I want to talk about also when, what happens when things go wrong. So when, for example, you're using someone else's content without their consent, how does the law handle responsibility for that? If there is a kind of, what's the state of play there?
Yeah, another good question, because it's there's some kind of general consensus, but again, maybe a little bit grey in this area. But a lot of legal experts think that the company that's produced the output is liable for the output rather than the model creator, so not the person that trained the model. So that then means that you, and that kind of makes sense, because if you're then going to publish that content after it's been created, you're then kind of responsible for the quality of what you're publishing. So you should check it, make sure there's kind of no misinformation, you're not stealing from someone else's copyright. But it's very difficult if you don't know how the model was trained, because let's say, for example, a lot of these image generators have checks that if you ask for Mickey Mouse to be produced, or some Disney character, they know to reject that prompt, but that's been hard coded in. So that one's kind of obvious. But what about like a small character that's not so popular or famous, and the developers didn't think to do that? Or if you try and work around it and you say, do you know what, I kind of want a cartoon mouse that's doing something funny, and it might have the most training data it's got because it was trained on maybe Disney content, then it's coming out with something that looks similar to Mickey Mouse. And if you just don't happen to know that that's a fair likeness of someone else's IP, it's very easy to get in trouble. Now, obviously, that's a really obvious example, but if it was a less known character, then I could totally make that mistake where I think, oh, that's a really cool mouse you've made, and not realize that that's someone else's character. There is also, I think it's Article 17 of the EU's Copyright Act as well, says that actually that the platform that you publish on can be liable. And this is trying to kind of balance the rights of copyright holders and with the kind of responsibilities of platforms. So if you think, for example, this could be YouTube, it could be social media like TikTok and that. If you are allowing copyrighted content to be published, or AI generated content to be published that shouldn't be, you can actually then sue the platform. But then this is really tricky, because how does the platform know if it was generated? And you could argue, okay, well, every time you post a picture on Instagram, maybe a human should review it and check. But then how is that human, to my previous point, going to know that that's a famous character, or it's not a famous character, but it's someone's character, less famous one? And then also, if you post something and it's not instant, you're kind of breaking the platform. Like we do something at the weekend and we want to tell our friends about it, and we put it up. If you have to wait like 3 days for someone to review it before it goes up, that quality, that timeliness is lost. And you can't really automate it. There are some tools claiming to be able to tell if content is AI generated, but it's very difficult. I've seen a lot of them being very hit and miss at the moment, because the quality is just so good, and it appears to be original and unique, without them also kind of scraping everything on the internet and comparing it one to one. How are they supposed to tell if it's come from something else, especially if it's a merger of multiple sources as well? To some even definitions of creativity refer to that, taking multiple things and making something new from it. So it's a really tricky one. But I think in general, if you're publishing it, you should kind of try and take responsibility, make sure that it conforms as much as possible. And if you are a content sharing platform, then just be very aware that they're offering into the EU, which would be most of them. Then just be aware of Article 17 of the EU copyright and the kind of digital single market directive.
Yeah, thanks, Damon. It's a very interesting topic. It's very complex, I think. Hearing you talk about some of these different areas of copyrights and IP, and I think it's if you are a lawmaker, it must be very complex to create new laws about this topic as well. So I wanted to conclude this talk by focusing a little bit on that. If you are a lawmaker, how do you balance? And we talked about this in some of these in these talks. How do you balance, the necessity to protect copyright and IP with the need for creativity, to innovation as well? Because too many controls on IP might limit innovation and might limit the development of AI in the future. So if you were a lawmaker, how would you balance these two competing forces?
Yeah, that's the golden question, and I think they're really struggling with it at the moment. So the World Intellectual Property Organization is actually trying to work on a global AI and kind of intellectual property framework, but To your point, there's different national views on copyright originality, the duration, how to enforce it. There's also, as you say, like balancing innovation in kind of AI tools with the actual kind of content creators' rights and copyright. And then there's like in terms of licensing, the licensing right now is also a bit of a minefield. Everyone's creating licenses to use AI, but they're very different, and it's pretty much the company that owns the rights holders. They are just coming up with licenses. There's no kind of conformity there. So actually getting all of that to conform is really challenging. And also to your point then, I don't think anyone would disagree that ChatGPT, the output of that is incredible. If you look at what we had a few years ago, and now you can get it to write a poem or a story or help you with research and stuff in a way that just wasn't possible before. And that was only possible because they went and scraped the entirety of the internet, and it enabled them to have so much data that the quality of the output they can produce is excellent. But then the problem is, if they're now producing, DALL-E producing images or ChatGPT producing stories, that from images of artists and stories of writers who are now getting less work because their work was without their permission used to train it. While it's great for kind of the masses, the individuals who are actually producing the works are suffering losses as a result, and you need to kind of protect them. So fine, it might reduce costs in one place, but then you're reducing income in others. So, but if you block that, then we wouldn't have models as good as OpenAI. Now, it might be that we actually need multiple different approaches for different industries and different topics. So if it comes to media content, it may be that actually, no, we need to support, like in the media and entertainment industry, we need to support the creators so that they can create new and good stuff, which they may then license to train models to be able to produce more great stuff. But if we don't support them, then they can have the funds to create more content. While in medical, for example, I know personally, I'd be more than happy, and this does cross over privacy as well as kind of copyright, but I'd be more than happy to give away all of my data, preferably anonymized, but if that helps cure a disease and save lives, and to some extent, should the governments just say, do you know what, we are going to give away, if it's for the kind of public general good, do we just make it completely legal? We'll support any innovation as long as it saves lives, helps people, that kind of thing. But as soon as you start causing losses for companies, then no, we're going to block that. So it might not be one rule fits everything. They might have to even come up with different rules for different industries or different use cases. So yeah, definitely a golden question. No answer right now, and this has been struggled and tangled with for years now. But the World Intellectual Property Organization and various intellectual property offices of each country are wrestling with this one at the moment, and I don't think there's a single right answer, and I think some of them have chosen not to make a decision, and others are still in debate.
Thanks, Damon. I think we've understood today that it is a complex topic, as I said earlier as well. And as you said, there are no right answers, but it's good to learn and to know more about this topic, because I think it's a topic that will become more important in the near future. Okay, thanks so much for being with us today another time, Damon.
Lovely, thanks for having me.